The Michigan Deceased Trust Administration Timeline. Hi, I'm Darren Findling of the Probate Pro Law Firm. I'm going to walk you through a basic trust administration timeline that generally explains how a trust is administered when somebody has died. Every trust matter is unique, though, so it's very important to work with your lawyer who is helping you with this trust administration process to understand the particularities of your trust administration. This is just a general framework to understand how a trust is generally administered after somebody has died. Let's work our way through it. It begins with the person who is serving as the trustee accepting that appointment as trustee, and a certificate of trust would be issued. It's kind of like the letters of authority in a deceased estate. The certificate of trust gives the authority of the trustee to handle the affairs pursuant to the trust, the powers that are defined within the trust and the duties as set forth by statute. This is the document that can be used with financial institutions, maybe to sell real estate, whatever it may be as it relates to administering the trust. It is the certificate of trust that's created to give that person the authority to act. The next document is, or the next step in the process, is giving notice. Notice to the beneficiaries of the trust, notice of the relevant provisions of the trust that of which those people may have a right to. So you don't have to give them the whole trust, you have to give them the relevant provisions of the trust that are applicable to them as trust beneficiaries, as well as a typical notice letter under the statute MCL 700.7604. This defines the rights of, or provides notice of the rights of the trust beneficiaries to object to have an opportunity to object to the trust itself, and it starts the statute of limitations clock to begin. So it's really important to give notice to the beneficiaries of the relevant provisions of the trust, as well as providing the requisite rights as set forth under MCL 700.7604. You'll also notice that there is a yellow bar at the top of this timeline. It reflects that there is a 4-month creditor period. So notice to creditors is really an important phase of trust administration. You are required to give notice to known creditors. These are creditors you knew of or should have known of, as well as publish in the legal news for any unknown creditors, creditors you wouldn't reasonably know of. There's a body of statutes that define the process relating to creditors and the requirements of a trustee to provide notice to creditors to ensure that you are administering the trust appropriately according to law and giving the trust claim creditors, or the creditors, an opportunity to file claims as it relates to debts that the trust may be obligated to. So from there, you're going to start gathering assets. Now you can see within this timeline, I'm not putting a lot of dates on here because really a lot of these things are occurring all at the exact same time. So you may be gathering assets right at the beginning, or you may be gathering assets throughout. But really what we're doing is we're identifying how assets are titled. Are they titled in the individual name? Are they titled in the trust? Maybe they're titled in an LLC or business entity. We're trying to understand what are the assets that are being administered through the trust. What is the nature of the asset? Who is the holder of the asset? Where the asset's being held? The approximate valuation of the asset, and whether it is titled in the name of the trust or not. So this process can go on for quite some time, and then eventually an inventory is prepared and served upon the trust beneficiaries, letting them know of the assets as of the time that the trustee became the trustee, a snapshot really relating to generally date of death that identifies the trust assets that are being administered through this trust. In addition, we're going to administer these trust assets. Now, I keep speaking about trust assets. It's important to understand there's a difference between an individual asset, an asset that is an individual's name that may flow through the probate proceeding, and a trust asset that's being administered through the trust. It's also important to delineate and differentiate between an asset that may have a named beneficiary, like a life insurance policy, or a jointly held asset of which the survivor would take. So depending on how these assets are titled and whether there's a joint owner or a named beneficiary are going to determine which bucket you put these assets in. Are they going to flow through probate? Are they going to flow through the trust administration? Or are they going to go to the survivor in a joint account or the beneficiary of a beneficiary designated account? In addition, you're going to resolve the debts. Now, I coincide that with a 4-month period because the creditor period is generally 4 months from notice to kind of start that clock 4-month process. Again, I'm painting a broad paintbrush stroke here because there are very important rules relating to how you address creditors that may file claims and making sure that during the trust administration that you have appropriately provided notice so that when you do distribute the trust assets, you're ensuring that a later identified trust claimant won't come forward and disrupt the trust that was just distributed. So again, resolving debts could include unsecured debt, like a medical bill or maybe a credit card. It can include secured debt, like a lien on a vehicle. And it can include tax debt, like debt owed to the IRS. So again, you're addressing all of the debt. And I don't talk about paying the debt or settling it. You have to resolve the debt because there are particular provisions in the statute that identify how you address the payment of debt depending on various or depending on whether there's sufficient assets in the trust to address all of the debt and whether the claimants, creditors, have appropriately filed claims. You'll see that also at some juncture you're going to be distributing the trust assets. Now that may just simply be distributing cash. It could be distributing real estate. Again, very particular provisions of the statute that identify how you are to distribute in like kind. And what that generally means is you can't favor one trust beneficiary over the other. You are obligated to provide a distribution. Now, there are times that there are interim distributions and then a final distribution that is often very common in trust administration. And then at some juncture, when everything is done, when all of the responsibilities of the trustee are concluded, you would close the trust. And you do that through a paperwork process because most trusts are not administered through the probate court. Although it can be administered through the probate court, many or most trusts are administered outside of the jurisdiction of the probate court and are administered in the privacy. And all of this information that we're discussing here is not public record. Now, if a trust is being administered through the probate court, then much of this timeline still holds, yet there are requirements for filings that may occur within the probate court itself. Again, as I started this explanation, this is just a general timeline. The idea is to give you a basic understanding of what it means to administer a trust. But trusts come in all shapes and sizes. There are all different types of language that could be included in the trust. So this is a general framework. Please do not rely on this particular explanation to guide you through your particular circumstances. You should work with a skilled, competent probate practitioner, somebody that understands how to administer a trust to ensure that you're abiding by the provisions of the trust, as well as all of the statutes, the court rules, and case laws that may apply. At the Probate Pro, we are passionate about everything probate and trust. If you've got questions about this particular timeline, administering a probate estate or trust estate, feel free to reach out to us at 833-PROBATE or visit us at theprobatepro.com.